Good morning, Colorado. This is the Colorado Oil and Gas Conservation Commission Rulemaking, Day 6, Week 2. My name is Jeff Robbins. I'm Chair of the Colorado Oil and Gas Conservation Commission. We have with us our commissioners, and we have with us 83 participants this morning and counting. If we want to get started, we were to start at 9 o'clock. It's 9:02. Hearings Officer Larson, could you please conduct the roll call?
Yes. Commissioner Bogue.
Present.
Commissioner Gonzalez.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Putnam.
Here. Good morning.
Commissioner Robbins.
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Very good. Well, welcome to everyone that is participating with us this morning. Let me sort of set the stage on where we are, where we've been, and where we're going. We had last week initiated our rulemaking, and on day 1, we undertook public comment of over 100 participants. We also received written public comment of over 100 participants as well. We then engaged, we have 6 rulemakings for this 3-week period of time. Collectively, it's 1 rulemaking, but it's 6 different series. So we started with our 300 series of rules in which we initiated sort of an overhaul to the permitting process itself. We successfully got to a conclusion of listening to public comment as well as witnesses and party presentations on 300. We provided direction to staff of sort of areas in which direction the commission desired to go. We look forward to receiving from staff a red line consistent with that direction, and then later this week we will revisit sort of the landing spot of the 300 series. We are now halfway through the 500 series. These are the rules around our rules of practice and procedure. We initiated this on Friday and received some of the testimony on Friday, and we're going to jump back into that this morning with a dozen or so parties presenting testimony on the 500 series. If we come close to our agenda, by this afternoon, we will have gotten through the 500 series public comment and party statements, and then we would move to deliberations on the 500 series this afternoon. We would hopefully continue deliberations on 500 series tomorrow, concluding tomorrow afternoon. And then we would move to our 400 series, which is the rules around operations and reporting. We have a couple of days set aside for that. And then we move to the 600 series, which is the safety and facility operations series. And then I think toward the beginning of next week, we move to the 200 series, just sort of the general series, setting the stage for all of our other rules. And then we would revisit all the series together. We've talked a lot about each rule set being a piece to a puzzle. We would attempt to put all those pieces together mid to end of next week, and then conclude with the 200 to 600 series. We then would take 2 weeks off and get prepped for the 800, 900, and 1200 series. And then we would come back toward the end of September, early October, and tackle those series as well. All of this with a proposed effective date of December 1 of 2020. So with that, Ms. Larson, I believe we're ready to move into party presentations on the 500 series. I believe the first series of parties, a panel of 3 groups, Broomfield Health and Safety First, Citizen Groups, and Oil and Gas Education Project. I believe that's the initial party presentation. I see Mr. Freeman has joined us. Do we have others that will be joining this panel?
No, Commissioner Robbins, it'll just be me this morning.
Okay. Thomas Delahanty also joined, it looks like. So
yeah, go ahead and bring him in too.
okay. All right. With that, Mr. Freeman, do you have a PowerPoint? Are you sharing your screen?
No, Your Honor, I'll just be speaking today. I did stay around to the very end Friday, so I got your request to address some of the issues regarding the record on variances. And we can incorporate that in our prepared remarks, or if you'd like, I can wait till the end and answer questions on it, whichever.
I'll just,
I'm sorry?
yeah, tee it up a little bit, but we can also ask questions about that. I had asked questions of other parties as well. A couple of procedural matters that Ms. Larson asked me to cover that I failed to cover. One, if parties do plan on presenting PowerPoints, if they could email them to Ms. Larson, that way we can make sure commissioners have ready access to them. And then secondly, we do anticipate closing statements later this afternoon on the 500 series. If parties desire and if they have time allocated, please let Ms. Larson know of your intent to do closing, and if so, for how long. And Mr. Freeman, I have this set aside as a 20-minute presentation from your group. Is that still accurate, or have you adjusted that?
No, we won't need that much time. I was thinking probably 5 to 7 minutes for our prepared remarks, and then maybe about another 4 or 5 minutes to answer your question, and I can put that all together if you like.
Sounds good.
Okay, thank you.
All right, I think you can take it away.
Thank you. Good morning. This is Michael Freeman on behalf of the environmental groups, and I'd like to address two issues this morning on the 500 series rules. First, variances, and second, the new Rule 507 standard for stand-in. With regard to variances, we asked, like the Grand Valley Citizens Alliance parties on Friday, we asked that every variance request should require approval by the commission after a hearing, rather than being approved at the staff level. To assess what that might mean in practice, we did a review of what types of variances have been granted in the past. From 2014 to 2019, the monthly staff reports listed variances each month that had been granted. During that time, there were 99 variances granted over a period of about 64 to 65 months. That comes out to an average of 3 variances every 2 months. Now, as one of the industry witnesses pointed out Friday, some of these variances applied to multiple wells or multiple locations, but we counted them according to how they were presented in the staff reports, so that if there was one entry, we counted it as a single variance. And if that pace continues, in other words, 3 variances every 2 months, we don't think it would be burdensome for the new professional commission to address and decide each variance request. That's especially true to the extent that most variances are innocuous or unopposed, as the industry parties described. Where that's the case, a variance can be addressed simply on this commission's weekly consent agenda. I'd also note that that's how the Colorado Public Utilities Commission does it. Like this commission, the Public Utilities Commission is a full-time professional board, and the commissioners there decide all variance requests themselves. So we'd suggest that this commission can take the same approach. As proposed, however, Rule 502 would have the commission decide variances only where they affect public health, safety, welfare, and the environment, and that staff would grant variances that involve procedural matters. But that presents a difficult question that's not really addressed in the proposed rules, which is how do you distinguish whether a variance affects the environment or not? And I think that's an important distinction because procedural matters are often highly relevant to environmental impacts, and it's not clear how that distinction would work in practice. Just a couple of examples there. One of the most common variances we found, and there were a dozen or more of these, involved a request to approve drilling permits without public comment or before the end of the public comment period, so that the operator could start drilling more quickly. That typically occurred, and the variance was typically granted in cases where the operator wanted to move forward more quickly without having to pay additional charges for a drilling rig. That's a procedural variance, but it also means the public didn't get a chance to raise its concerns, and the staff may not have learned about environmental issues that were raised by that permit. In another example, some variances were granted allowing operators to delay submitting their cement bond logs on newly drilled wells for a period of up to 2 years. And the filing of the cement bond log is also a procedural requirement, But the CBLs are a really important part of making sure that wells are properly constructed and that groundwater is protected. So rather than trying to distinguish what variances are a concern for the public or a concern for the environment, we think it's just more appropriate for the commission to make these decisions itself. Requiring a commission hearing for variance is also worthwhile for transparency reasons. And that's because many of the variances are granted at a stage where there's not going to be any opportunity for public notice and comment at all, normally. For example, the industry party is pointing out Friday that a lot of variances involve reclamation issues. But the 1000 series reclamation rules don't require any notice and comment. The staff reports on the reclamation variances don't indicate whether the landowners had been paid by the operators to waive reclamation requirements, but it is clear that even where the landowner agrees to waive or agrees to a variance on reclamation, not doing the reclamation can have environmental impacts. And that's especially true in western Colorado, where there's wildlife habitat involved in the area that should be reclaimed. So I think there, without any notice of comment, it would be difficult for the public to weigh in, and there'd be no transparency for those decisions. We also found a number of variances, I think there were 10 of these, from the requirements for wellbore construction. And those are requirements that are usually applied through the Form 2s. But as proposed, the staff proposed rules wouldn't provide any notice and comment opportunities on Form 2s. So there really would be no way for the public to know if an operator is seeking a variance from the Commission's new wellbore integrity rules, or if there's a problem with complying with the casing and cementing requirements. And a key part of the wellbore integrity rules is to protect groundwater and ensure that wells are properly constructed. So this is an area where members of the public and nearby water well owners may have significant interest and concerns. Variances are also a concern, and it's really especially a concern where they disproportionately impact communities, or where variances are sought from setback requirements. As you heard Tricia Nelson and others testify, it's just not realistic to expect members of DI communities to monitor this commission's variance proceedings and to engage effectively within the relatively short time that's allowed, where they're already dealing with all kinds of other issues. And with regard to setback variances, those variances have a major and direct impact on nearby residents who, even if they're not in a DI community, they may not appreciate what's happening with the variance until it's too late to represent their interests. So in our filings, we've asked the Commission to consider not allowing variances at all from residential setback requirements or where DI communities are involved. But at a minimum, the Commission should provide substantial additional procedural protections in those situations above and beyond just the Commission hearing. For example, the Commission could require the operator to do additional outreach to the DI community involved, or additional outreach to the residents who would be affected by a setback variance. Also, providing additional technical assistance like an ombudsman would be a really valuable step. Now, turning to Commissioner Gonzalez and Robbins' question from Friday, we did find examples of variances that presented potential concerns for public health and the environment. I want to be clear here, though, we're not saying that past directors were granting variances that allowed significant environmental damage to occur, or that variances were granted irresponsibly. There's really just not enough information in the staff reports to draw those conclusions, and many of the entries in those reports are really cursory. And so I think those variance decisions may have been entirely reasonable under the circumstances, but we just don't have the details to make that assessment, and we're really going off the staff descriptions. What is clear, though, is that a number of variances involve issues that could affect environmental protection in a significant way, and where we think review by the Commission would be definitely warranted. And just a couple of examples. In 2 cases, the director granted variances from the requirement to connect a new well to a pipeline where it's practical to do so. And those variances apparently involved operators who wanted to go ahead and drill a well and flare the gas from that well for several months with resulting air pollution and carbon emissions. From what we gathered, the companies had already contracted for their drill rig, and they wanted to move forward with drilling while they were still negotiating with the gathering system provider. In that case, the commission allowed them to flare for, I believe, 4 months without connecting to the gathering system. In one case, an operator had a leaky well bore. The well bore had apparently failed a pressure test, and the commission allowed the operator to continue operating the well for 6 months before repairing it. The idea, as we understood it, was to give the operator time to make an economic decision on whether to repair the leak or to just plug and abandon the well, and presumably that would be based on how much the well was producing. The variance did include conditions that were aimed at preventing impacts to groundwater, but again, this was, I think, a case that certainly involved environmental risks. And then finally, a number of variances we found, and I think there were 13 of these, were issued from the commission's setback requirements. And those setback variances don't appear to have involved a waiver of setback from homes. Instead, a lot of them involve letting operators work in close proximity to power lines. But to the extent this commission ultimately expands the residential setbacks in your rules, I think setback waivers could become a bigger issue and one that would warrant this commission's review. Now, turning to our second issue on the 500 series, that's the question of standing. We just want to strongly support the new effective person standard. As Commissioner Robbins and Leslie Robinson from GVCA said Friday, the commission in the past has put up major barriers to public involvement. And the new effective person standard is really a sea change and a very positive one. And we just want to express our thanks and appreciation for the commission and the staff for moving in that direction. However, we would like to raise one issue with Rule 507 on standing. As proposed, the rules carve out one exception from their effective person standard. Rule 507, as proposed, would create a blanket prohibition on members of the public becoming parties to drilling and spacing unit applications, even where that drilling and spacing unit would adversely affect them. This is the only category of decision in the proposed rules where the commission would not let members of the public become parties. For every other action, standing will be based on the effective person test. And we think that the same standing standard, the same standing test should apply for drilling and spacing units as for other decisions. A drilling and spacing unit determines the number of wells and location of wells that could be drilled in an area, and that can definitely have impacts on members of the public. One of our witnesses, Sean Cuevo, in his written testimony, for example, describes that he's dealing with a drilling and spacing unit application filed by Extraction for a large area of Commerce City. And in fact, on its face, Rule 507 recognizes that drilling and spacing units can have surface impacts. It would provide that the CDPHE and Colorado Parks and Wildlife have automatic standing when they request it for a drilling and spacing unit application. Those agencies are concerned with the same types of surface impacts to wildlife and public health that also concern the public. So there doesn't appear to be any reason to think that categorically members of the public will never be affected by drilling and spacing units. Now, just to conclude, I want to say it's important that we're not asking for automatic standing here. A member of the public would still have to show that he or she may be adversely affected by a drilling and spacing unit. If the applicant can't show that, then they won't have standing. But we're just asking the commission to take the same approach here and allow members of the public to participate where a drilling and spacing unit will affect them, just like the proposed rules would do for every other commission decision. And so with that, that's all I have, and I'm happy to answer any questions. Thank you.
Thank you for that presentation, Mr. Freeman. And I think you did a good job of covering my question too. Do commissioners have questions for Mr. Freeman or his cohort, Mr. Delahunty, who's also with us? Mr. Gonzalez. Commissioner
Thank you,
Gonzalez.
Mr. Chair. Good morning, Mr. Freeman. I'm curious about the variances that, well, first of all, I appreciate you addressing what we brought up in comment last week. Very helpful. I wanted to make sure we saw all sides of the history of variances really, and really get a good understanding of that. So with regard to this, both the pipeline connect variance that resulted in flaring and the leaky wellbore variance that had some COAs attached to them. With those two variances, what was the timing on those? I know you looked back to 2014. I'm curious what the recency of those are.
Sure, let me pull my notes up here. I can answer that. So the pipeline connection one, those were reported in the January 2019 staff report. And the leaky pressure test was reported in the October 2015 staff report.
Okay. Thank you.
Sure.
Commissioner McGowan.
Thank you, Mr. Chair. And maybe staff can help me out with this a little bit, but as we think about alternative analysis and how that's going to work, is that going to help people understand where a drilling and spacing unit would be located? I'm trying to figure out, would some of that already be addressed in ALA and people would know where it's going to be located, where wells are going to be and how they're going to be spaced as part of alternative location analysis, or no?
Director Murphy.
Thank you for the question, Commissioner. For me, when I think about the ALA, it relates mostly to a surface location that would be tied to what minerals are being developed. I mean, I think that would be part of the conversation on some level, because the minerals will, you couldn't drill a horizontal well from Western Kansas to develop minerals in, the DJ, in the middle of the DJ Basin. But so that I think that there is some information there, but I don't know that it's as direct as maybe your question has contemplated.
Commissioner Gonzalez, did you have a follow-up?
I'm sorry, no, I didn't take myself off mute.
Not a problem. Commissioner Nanjapa.
Thank you, Mr. Chair. I just had a question. My sound kind of blinked out a little bit when you were discussing reclamation, Mr. Freeman, with respect to the 1000 series. And I think you were talking a little bit about the transparency or where staff was involved. Could you just repeat some of that, please?
Sure. So I guess our point was, as the industry witnesses described on Friday, a lot of the variances that are granted involve variances from different reclamation requirements. And the point they made was that many of those variances are actually approved or requested by the surface owner, whether they're fine with leaving a road in place or not reclaiming a well pad. And the point I was making with transparency is that the reclamation requirements are implemented through the 1000 series rules, and there's no public notice or comment required for the reclamation process. So the public has no way to tell whether reclamation is being waived or excused in those circumstances. And there are cases where a decision not to require reclamation can have effects on wildlife or other resources, particularly in Western Colorado, where reclamation is more difficult and it can be an area that's important for mule deer or other species.
Commissioner Nanjapa, any follow-up?
Yes, Mr. Chair, just briefly, I think, so just to understand in your kind of broader overarching comments that all variances should be heard by the commission, is that part of this suggestion that would allow for the public comment? Is that correct?
Right, that if it would be noticed for a hearing by the commission, so the public would have an opportunity to at least if they were following the commission's process, see what's happening and have a chance to weigh in and submit any concerns or become a party if they were concerned as well.
Thank you.
Commissioner Messner.
Thank you, Mr. Chair, and thank you for the presentation. I thought that was informative. I did just have a question, and it's probably for staff, but to make sure that I understand. So Rule 507 contemplates the ability for a person who may be adversely affected or aggrieved by an application to submit a petition. As I read that, it indicates the term application, and so I'm assuming that application is an oil and gas development plan. Wouldn't that include both Form 2s and 2As in the oil and gas development plan, or am I missing something there?
I can try and answer that, or if staff would prefer. What's your pleasure?
It doesn't matter. I mean, I'd be curious to hear from whoever has thoughts on that. I'm just trying to make sure that I fully understand.
So
Take a shot at it, Mr. Freeman, and then we'll hear from staff.
So a couple things. I think first, under Rule 303, the oil and gas development plan includes the Form 2A, and then it also includes the drilling and spacing unit application, where the application is filed at the same time as the Form 2A. It's not, as I understand it, it's not required to be simultaneous, but sometimes it is. And so that creates an odd situation where, a member of the public may have standing to become a party on the Form 2A, but it may not be able to get involved in the drilling and spacing unit application. There also may be cases, and I hope staff will correct me if I'm misunderstanding this, where the drilling and spacing unit application could be filed separately. And in that case, a member of the public wouldn't have an opportunity to become a party at all. And what our concern is that Rule 507 lays out the standing test and the affected person standard, and we think on the whole that's all very positive and we support it. But then I believe it's 507G. It's one of the subsections says, for purposes of a drilling and spacing unit, which refers back to another rule, only I believe the mineral owner, CPW, CDPHE, and a couple of other government agencies can be affected persons. And our concern is that we think that the public or non-mineral owners should not be, per se excluded from party status there. They ought to have the opportunity to show that they're adversely affected or aggrieved if they want to become a party.
Does staff want to follow up on that question?
Add a few additional comments to that. So when drafting the 300 and 500 series rules, staff recognize that there may be circumstances when for instance, an existing DSU needs to be amended. So if there is a change in acreage, something has occurred that would require that original DSU to be amended, there would be the opportunity for the operator to come in and seek an amendment to that DSU. Then, of course, we have the OGDP, and staff's expectation is that when there is an OGDP, if there is a new drilling and spacing unit that is to be created, that DSU application comes in concurrent with the Form 2A. So at that time, those affected persons who meet the definition within the 500 series would be able to come in and seek a petition protesting the 2A. And it's at that point that the surface impacts and other impacts related to that OGDP are considered. So that was the reason for the distinction, recognizing that when you have an OGDP with a DSU, there is the opportunity and for the commission to consider concurrent the DSU and the surface impacts, and those individuals who are affected by those surface impacts have the opportunity to be heard as it relates to the surface impacts considered in the 2A.
Director Murphy, do you have anything to weigh in on this variance question?
I do on kind of the broader variance question, the more focused conversation that we're having on spacing and access. I may let AAG minor chime in and then
Okay, let's turn
I'm
to
gonna
AG
transition.
minor, and then we'll have you focus more broadly on the whole issue.
Thank you, Mr. Chair. I just wanted to point out that the converse of what Ms. Larson said is also true. The rules do contemplate the idea of perhaps still a standalone 2A being filed, but that would be in a circumstance where an existing Form 2A was being modified, for example, expanding surface location, or if an operator had already had a DSU approved prior to the effective date of the rules and was submitting a surface location associated with it. So while Mr. Freeman is correct that the rules do seem to contemplate the idea that there could be standalone DSU applications or 2A applications, they really are meant to sort of be part of addressing those changes to existing things that already existed before mission change, but after mission change for new projects, we'll see DSUs and 2As together in that unified permitting system. So there will be an opportunity for the public to engage on sort of both parts of that unified permit for new locations in the future.
Thank you, Attorney General Minor. Director Murphy, why don't you hold for a sec? Let's finish up questions of the panel, and then we can come back to you. Commissioner Gonzalez.
Thank you, Mr. Chair. One quick just clarification. You had stated some numbers about the number of variances that have occurred through staff reports from 2014 to some other end date. Can you tell me the number of variances? I didn't get that in my notes. And then 2014 to what was the other bracket on the date?
Let me find that in my notes here. So it was, hold on one moment here. So and this is exhibit 4 to our response pre-hearing statement. We put it on a table.
Okay.
And the time period ran from January 2014 staff report, so January 27th, 2014. And the last one, last staff report we covered was May 21st, 2019. So it was, I guess 5 years, 4 months, 5 years, 5 months, somewhere in that range, basically.
And how many variances was that, Mr. Freeman?
99.
99? That's
99, and again, that's based on how it was presented in the staff report, and that, again, many of those covered multiple locations and multiple wells.
Sure. Thank you.
Other questions for this panel? Okay, seeing none, thank you, Mr. Freeman, for your presentation this morning. We will Zoom you away, and as we're getting the next panel on board, Director Murphy, did you want to speak?
Yep, thank you, Chair. On the variance question, I think that the staff's draft reflects what we think may be an appropriate balance of decision making between the director and the commission itself. I think that this is a really important opportunity for you as commissioners to weigh what your workload wants to be, and as Mr. Freeman noted, bring more transparency into the variance process. And so that's how staff has approached it. But I think that 181 has upended a number of our processes by creating full-time commissioners and the things that come with it. And so this to me is a place where staff's proposal creates more transparency. If it doesn't go far enough, that's great. We're happy to have the commission itself take on more or different authority in that space, because to me it is a question, like many others in these rule series, about who is the right decision maker and for what decisions. And so but just to frame that question, I think that Mr. Freeman's presentation illustrated the opportunity to think about and to weigh. So
Thank you, Director Murphy, for those comments. We now have Commerce City ready for presentation. I see Commerce City's attorney, Mr. Sura, is in the room. Mr. Sura, if you want to speak, you have the floor. I have you down for 5 minutes, but you can, how much ever time you want. dependent upon how much time you were given. Ms. Larson, do we have Mr. Sura unmuted?
So let's see. We'll ask Mr. Sura to unmute.
Yes, sorry, there is no presentation today from Commerce City. We're reserving the time for the 600 series. I'm sorry that wasn't clear.
I apologize, Mr. Sura, for missing that. Thank you for clarifying.
Then that's fine. Zoom away, Mr. Sura. My calendar has, or my agenda has climate reality with a 5-minute presentation next, followed by Colorado Association of Mineral Owners.
Oh, am I muted still?
No, we can hear you, Ms. Rose.
Sorry, thank you. It was my video that was still out. Thank you, commissioners, for this time this morning, and thank you for your deliberations last week. I really appreciate the spirit in which you are undertaking this rulemaking. It's very clear, I think, to all of us who have been on the call that you are very earnest about your professional responsibilities, and I really appreciate that. So I'm going to take a macro view again today, and we're going to argue some specifics as we move forward with the 200 and 600 series. Again, for the record, I'm Jan Rose. I'm the party representative for Climate Reality Denver Boulder chapter. I want to begin by reminding the commission that the title of the bill under which this rulemaking is taking place is Protect Public Welfare, Oil and Gas Operations. So the primary issue now is to protect public health, safety, the environment, and wildlife. And more specifically, the first sentence is concerning additional protections for public welfare regarding the conduct of oil and gas operations. So if we take a look at this map from 2017, what we see is an astonishing number of wells, especially in the areas of heavy population in the state of Colorado. And this takes a look at the Front Range in general, the non-attainment zone, where we have a serious classification in the EPA of ozone and regional haze and effects to Rocky Mountain National Park, et cetera, that is going to be driving another rulemaking hearing later on this year at the CDPHE. The very, very red area represents primarily well. Yes?
I'm sorry. Are you sharing or we don't see a map. I don't know if you plan on sharing at this point, but if you're
yeah, I was sharing my screen. You can't see it?
No, ma'am.
Okay, hang on. Let me. I'm so sorry.
Okay, we'll take your time. Let's get your screen shared, and you're not losing your time.
Okay. Thank you so much.
Now we
can see it now. Okay, sorry about that. Picking up where I left off, so this is the number of wells in Colorado in 2017. And it really shows the location of wells within the heavily populated areas of Colorado. Basically, the only place without a lot of wells is the very high country. And of course, in the last year, there have been things like attempts to drill on the eastern border of the Great Sand Dunes National Park, on the very west side of Rocky Mountain National Park, in the Fraser Valley, where oil rigs would be seen from the chairlifts at Winter Park and Mary Jane, and in Jackson County, where they could be seen by the Steamboat Springs ski area. So those are some of the proposed oil and gas developments that are on hold as a result of the director's objective criteria and awaiting your approval moving forward. All these blue and green dots are future wells that have already been approved and are basically overlaying existing wells that already exist. And you notice this section of blues is moving down closer and closer into the east side of Denver, into Commerce City, and all the way down into Douglas County. So the encroachment into residential areas is increasing, not decreasing. Here's a look again at the Commerce City development, because I want to propose to you that while they have signed a regional operator agreement and have an MOU in place and have selected 2 well site locations that are in unincorporated Adams County outside the city limits of Commerce City, their intent is to drill all the way up to the Rocky Mountain National Park and with a view from Denver International Airport, so that all the tourists flying into Denver will have a terrific view of the planned of the oil and gas development plans right there at DIA. Here's another look that is not readily apparent when they provide the topographical coordinates for an oil and gas development plan. Again, this is out of date, but you can see here that they have interspersed the wells all through residential areas and near a large number of schools. I can count 6 just looking at this chart. And a reminder that Commerce City is sandwiched between the Suncor oil refinery, one of the biggest polluters in the state, and Denver International Airport, one of the biggest polluters in the state. So they are in a unique position, not only as a low income and primarily minority community, to be one of our most DI communities in the state, but they already have a really significant existing pollution problem. And you heard from Lucy Molina that they have been fighting this additional oil and gas development and additional pollution potential for almost 100 years and losing pretty much every single time. This is an example of a mobile home park with an oil and gas development plan right on, right outside of the Denver city limits. This is actually an aerial view flying into DIA, and it almost looks like oil and gas is picking on this mobile home community by locating the oil and gas operations right on its borderline, simply to save the need to build an access road. And I would certainly hope that time and care will be taken when you're reviewing OGDPs in the future to take a look at things like Google Maps to ascertain what it really looks like on the ground coming near these areas. Here's another example in Broomfield of an OGDP that I hope you will no longer approve. Yet another one. I can't imagine how home values for these communities are being affected. This is a fascinating chart to me because it almost looks like someone just laid down a ruler in the middle of the impacted area. Again, this is in Erie, and that sound wall is clearly having absolutely no protection and mitigation of noise. Here's the Livingston pad in Broomfield, and you can see the proximity of those homes and just imagine what it would be like if you lived in one of those homes. This is an oil and gas a processing plant that is taking place literally in the backyards of Anthem Ranch residents, and it's a monstrosity. I mean, we just simply shouldn't put heavy industry applications within feet of residential communities. This had to have been a variance even back then. This is not 500 feet. I don't know how it got approved in the first place, but I certainly hope you won't do it in the future. Yet another example.
Ms. Rose?
Now we're moving into Erie. Yes.
If I could get you to wrap up, you've extended beyond.
Sure, am I 5 minutes? Okay, this is Erie and Erie again and Erie again. And finally, this is our last request, that sensitive wildlife areas with signs from oil and gas development not be approved in the future, and that things like bald eagle and great horned owl habitat not be destroyed in this area for OGDPs. Thank you so much for your time. Sorry I ran over.
Thank you very much. We appreciate your participating with us and providing that input to us. Does any commissioner have questions for Ms. Rose? Okay. Seeing none, you did a good job. Everybody understood. We will zoom you away and bring the next panel on board.
Thank you.
I have the next panel as the Colorado Association of Mineral Owners. Is that right, Ms. Larson?
That is correct. And I'm currently not finding either Ms. Bargel or Mr. Neil Ray in the meeting. So give me a moment. We will take another look.
All right, I see Mr. Ray is present. Are you presenting for us, Mr. Ray?
Yes, and I'm just introducing Camero, and then I will introduce Cindy Bargel.
Okay, and I see Ms. Bargel is in the house with us. So if you want to get started, we look forward to hearing from you.
Okay. Good morning, Commissioners. My name is Neil Ray. I live at 5230 Lakeshore Drive, Beaumont, Colorado. I am the president of the Colorado Alliance of Mineral and Royalty Owners, CAMRO, whose offices are located at 1475 Wadsworth in Lakewood, Colorado. CAMRO is governed by an all-volunteer board of directors who own an interest in subsurface minerals, and very often they own the surface interest too. Our members are a diverse group of ranchers, farmers, citizens, family corporations, institutions such as hospitals, universities, churches, and charities. Our members are paid on over half of the producing wells in the state of Colorado. CAMRO members recognize that their mineral and royalty interests are a valuable real property interest long recognized in Colorado law, as pointed out earlier by Boulder County's council. That property interest, when contributed as a capital interest, is the very foundation of the oil and gas development that follows. On a personal note, my family has been involved in the mineral development of oil and gas and hard rock minerals in Colorado since the early 1900s. This is true for many of CAMRO's members. CAMRO members have watched the population influx and associated surface development occurring to accommodate our many new neighbors who are often surprised to learn minerals are a valuable property interest that may be separately owned and developed. This is true notwithstanding the COGC's work since 1998 to include language in every Colorado Real Estate Commission approved contract to disclose and explain the surface estate of the property may be owned separately from the underlying mineral estate, and third parties may own or lease interests in oil and gas, other minerals, geothermal energy, or water on or under the surface of the property, which interests may give them rights to enter and use the surface of the property to access the mineral estate, oil, gas, or water. That said, CAMRO recognizes the need to protect all Colorado with responsible regulation, as is prudent for the development of its resources, and appreciates the task before the Commission to consider how to fairly implement SB 181 mission shift. This shift from fostering to regulating development of our state's valuable mineral interest is not synonymous with preventing development. CAMRO is here today to further inform the Commission on those limited and specific notice and procedural issues in the 500 series of rules that impact CAMRO membership as mineral owners. CAMRO believes the mineral owners should have reasonable notice and the ability to participate in those decisions that impact their real property interest. We appreciate the Commissioner's comments that you want to hear all voices impacted by your decisions and hope CAMRO is among those that are heard. I would now like to introduce CAMRO's legal advocate, Cindy Bargel, who will further explain our issues with the 500 series of rules. Thank you.
Good morning, Commissioners. I'm hoping you can hear me. I'd like to share my screen, but I am struggling with that at present. I think I can go here. And I'm not sure, I think you're getting more than you want on that. I would only like to put up our PowerPoint, and that seems to not be coming through.
We see your PowerPoint.
Okay, and do you see more than my PowerPoint?
No, we just see your PowerPoint. It's not in view mode, it's in sort of PowerPoint mode. If you wanted to put it into slideshow.
You know, I don't have anything fancy to step through it, so I think I'll keep it in this mode. I've sent it to Ms. Larson, so she'll have that as well. And I apologize, it's just easier to step through it if that's okay, Commissioner Robbins.
That's fine.
Okay. Well, my name is Cindy Bargel. I'm an attorney with Visani Bargel, and I represent the Colorado Alliance of Mineral and Royalty Owners, along with other mineral owners throughout the state. I've been working in the oil and gas industry since 1981, when I graduated from the University of Colorado with a degree in mineral land management. After 10 years of working as a petroleum landman, I returned to law school and have since worked in various capacities, including as an assistant attorney general for this commission, as well as the state land board many years ago. For the last several decades, we've been focused on helping mineral interest owners better understand COGCC processes and the options that will hopefully create productive working interests. Thank you for allowing Camera to testify. We noted in our pre-hearing statement that this is the first time since 2007 a mineral interest owner hasn't been part of the commission, and we really do appreciate Commissioner Gonzalez's acknowledgement that mineral owners are not multi-billion dollar corporations. CAMRO members include dryland farmers from outside of Wiggins, retired school teachers from Littleton. In fact, you heard from the former CAMRO president, Michelle Smith, who was a small organic farmer, goat farmer. CAMRO members often have been in Colorado for generations, and they deeply care for the state. They're proud of their contributions to energy independence from foreign governments and their contributions to the state's economy. It does bear remembering that CAMRO mineral owners' interests are real property interests, not unlike the interests of the surface owners that you've heard from. And as Commissioner Baumgartner eloquently stated, albeit with respect to water rights, these resource interests are enduring. Mineral owners can't move their interests to a different locale. And as Mr. Ray pointed out, they support reasonable regulation of their property interest, but not elimination of it altogether. And they want to understand, just like surface owners, the impact on their real property interest. I will say that the analysis of the 300 series has been really instructive in this regard, and the unified permitting process, as we understand it, will answer one of our preliminary questions, and that is, as we understand it, and we welcome staff's input into that, that owners will be provided notice of an OGDP. And owners, as defined by statute and in the rules, includes those people who have the right to drill into and produce the mineral interest. So this would include not only operators who have leased that right, but also unleased mineral interest owners. So from our understanding of the unified permitting process, those owners should be getting notice. And that's similar to how drilling and spacing units are noticed currently. Rule 303E provides that that notice will be provided by hand delivery, certified mail, electronic mail, or delivery service with receipt of confirmation. This does advance everything that you've talked about regarding community engagement. But what we understand as well is there are really two types of notice that come to mineral interest owners. One is with respect to OGDPs, the other is with respect to applications filed before the commission, and that's handled in Rule 504A. And 504A states that when any proceedings been initiated, the commission will require a copy of the application together with the notice, and that will go out from the commission in accordance with the statute, which is part of the Act 3460-1084. 1084, as we point out, says that the commission gives notice either by mailing a copy of it, postage prepaid, to the last known mailing address of a person to be given notice, or by personal service. We really want to focus on this notice issue because now we see it in the 300 series and in the 500 series, and believe that it's really important how this notice provision is implemented. We also want to note as a sidebar that even though unleased mineral interest owners will receive notice, that notice of operations will go to their, if you are a leased mineral owner, that notice will go to the mineral lessee. And ostensibly that shouldn't be a problem because there should be a relationship between the parties and they can rely on that relationship, but that's not always the case, although that is, with respect to statutory pooling, a discussion for a different day. One of the things that we have noticed as CAMRO, and we do appreciate inclusion in the statement of basis and purpose, is that mineral owners often do not receive notice. The statement of basis and purpose now says that if a company actually knows the address, they'll send the address to the actual address, they'll send notice to the actual address they have. The statement kind of belies the problem, and that is operators don't have a standard for determining a mailing address. There's no standard for determining an email address. Really, there's no standard for determining how will people get this very critical notice. CAMRO has really two proposals that go beyond that, or go to that issue. One, as we said in our pre-hearing statement, is to create a working group to identify best practices for locating interested parties, particularly in this electronic age. And the other is to create some sort of registry to provide notice, including mailing addresses. It's interesting because in 1969, when the General Assembly first said, okay, Commission, you can send out this really important real property interest notice by mail, they included in the statute a provision that says parties can file with the Commission an address that can be used for notice purposes. Typically, this has been used for sunshine law list purposes where all notices go out, but maybe this could be used as a critical first stop for operators to find people and for people, mineral interest owners and others perhaps included, to provide information to the Commission. So notice again is something that we've complained about honestly for a long time, and we think that because of this increased request for community engagement, that this is an opportune time for the Commission to look to how people actually are going to get notice. It's only as good as when it gets there. One other issue that we want to touch very briefly on is the addition of Rule 503G5, which is a payment of proceeds provision that identifies what mineral interest owners need to do if they want to bring a payment of proceeds action. This is the genesis of this is out of Section 118.5 of the Act that provides a process for payment of proceeds. You'll note that in the addition of the payment of proceeds rule, there is a requirement that the mineral interest owner comply with rules 429 and 430. And when you look at those rules, when you look at those sections, you'll see that those are really complicated calibration rules where the forms that are required of mineral interest owners are only mentioned toward the end of the form. And what we're really asking for is a more streamlined process. That would include looking at the forms that are 38, 37, and 38 that mineral interest owners are required to provide, as well as considering a process that would allow mineral interest owners to come before the Commission and determine whether there's a bona fide dispute regarding a contract initially. Some mineral interest owners have waited years just for this jurisdictional determination. And so CAMRO respects the fact that there's transparency and streamlining, and to have a party wait for years to know if there's jurisdiction over the dispute doesn't seem consistent with Rule 181. So we'd like the Commission to adopt a fair and reasonable process, understandable to mineral owners, that allow for that preliminary determination. And that may include revision of those forms 37 and 38 that existed without revision since 2010. We also just wanted to point out that we really appreciate and support the revision to Rule 312 as it was written to allow parties to participate in proceedings before hearing officers and administrative law judges, as well as the Commission. CAMRO does weigh in periodically on things that we believe are of particular interest to mineral interest owners. One of those things has been notice, another has been the length of time or duration, which you guys have discussed regarding how long Commission proceedings are effective. Remember that without a termination date, mineral owners are locked in to both oil and gas development processes as well as caps, and that their leases can be tied up and their mineral interests can be tied up for the duration of time that you all pick. So those times are important to mineral interest owners as well.
Ms. Bargell, if you could wrap up your oh, there we go. Look at that.
And thank you. That concludes our testimony. We'd be happy to answer any questions. We do have experience with variances as well from farmers and ranchers across the state. We don't have the depth of data that you heard earlier today, but we know this is a big task, and we're just hopeful that these interests of CAMRO members are taken into account as you all move forward.
Thank you very much. Do we have questions for the panel from commissioners? And Ms. Bargell, if you could stop sharing your screen, it makes it a little easier for me to see all the commissioners.
I would be glad to. Thank you.
Commissioner McGowan.
Thank you, Mr. Chair. Thanks for coming and testifying today. I'm wondering if the commission creates this voluntary registry for mineral owners to register so that folks know where to find them, if the working group is necessary to figure out how to better find mineral owners.
That's a great question. I think we've been considering how best to find people, and you guys clearly are doing that on so many levels. I think the working group will be helpful because it's not just registering mailing addresses. It's how do you best determine email addresses? How do you look for people so that you have the broadest base participation you can? There are oil and gas companies that have done this obviously for years, often through title opinions that provide old addresses, which is where the disconnect has come up periodically. So I think a working group might tease out some of the best practices on how do you find people. I heard discussion earlier about, do we tell a school? Do we tell their administration? Do we tell their, who do we talk to when we talk to a school? Who do we, do they then tell parents? Who do we talk to when we notify? You have now an obligation to notify not just the surface occupants, but the tenants within a building. How does that work? How do you get their email addresses? Mineral interest owners is I'm sure Commissioner Gonzalez would attest, the location and the depth of information required to find people is really hard. And we'd like to be part of the process of making that maybe more attainable and easier, but it could be a registry that could help others as well. So that's where the working group would come in my view.
Thank you for that answer. Other commissioners with questions? Commissioner McGowan, you still have the floor.
So to the point of figuring out jurisdiction first before to be more expedient in figuring out if someone is being properly paid, if I'm understanding this issue correctly. I talked a little bit to staff about this. It actually sounds pretty complicated, and I'm wondering if you have anything specific in mind that would help staff figure out more quickly, or the commission figure out more quickly, whether or not there is jurisdiction, and whether or not it's an argument over what's in a contract, which is different. And I agree that it makes sense to know up front whether or not something belongs in front of the commission, and whether or not someone's getting their royalty payment versus they're just arguing over different parts of the contract, if I'm understanding this issue appropriately. And it sounds very complicated, and I'm not sure that there's a simple answer, and I'm wondering if you all have something specific in mind that you think that the commission should be doing to help this be more expedient.
I'll take that if it's okay, Neil.
That's fine. Yes, please.
Thank you. You are absolutely correct. It is really complicated. And so we are looking for some simplicity around it. I think that the forms 37 and 38 originally were intended to help in this regard. So one of the things is they are outdated, and staff has said that they'd be willing to work with us on those. They're from 2010. So that's one step. The second, I think, step is to create a preliminary process. If you look at 118.5, section 5.5, and I'd welcome any of the AAGs to speak to this, it says that the commission has the obligation to make a determination if there is a dispute regarding contractual rights. So even though it is complicated and might be hard, it's part of just like all the other complicated and hard things, frankly, you're being asked to do. And so I think that perhaps looking at a streamlined process where an ALJ who's experienced with contract issues, a hearing officer, you guys could look at what's been pled and say, really, this is a dispute about how to interpret a contract. These disputes coming before the commission are relatively new, actually, Commissioner McGowan. I mean, coming to you guys with the veracity and being having certain operators make requests that they come back to you even after they're filed with where they've traditionally been determined in the courts. And so I think, this one needs a closer look to create a simple process, starting with the forms and then coming up with a way where both parties can fairly be heard. And then the commission, who's called on to make this determination, can make it.
Thank you for that answer, Ms. Bargel. Do we have other questions for the panel?
Mr. Chair,
Yes.
Ms. Bargel suggested that that perhaps one of our AAGs could chime in on this matter of the commission itself engaging in determinations or interpretations on private contractual matters. And so I'm curious if we could hear from AAG Minor or AAG Davenport on that.
Or Director Murphy.
My request would be to have AAG Davenport chime in. I think he's steeped in this.
Magically appeared. Attorney General Davenport.
Yeah, sure, happy to. Thank you for the question, Commissioner Gonzalez. If you've got a specific question, please let me know. I agree with Ms. Bargel that the commission has an obligation pursuant to section 3461.18.5 to ensure that has jurisdiction over any payment of proceeds matter presented to it. That statute does provide that the commission does not have jurisdiction over a dispute that involves interpretation, a bona fide dispute over the interpretation of a contract. Do you have a more specific question?
No, I don't have a more specific question. It was kind of a general question, something that that I had not considered up to this point about this request about engaging in contract interpretation. And I understand that the payment of proceeds limitation, and so I wanted to understand the bounds of that jurisdiction for us. So that helps.
Sure. One thing I will mention is that we are in litigation right now over that exact issue of the boundaries of the commission's jurisdiction in payment of proceeds disputes. And so I'm happy to talk more with you, but I think it would be appropriate to talk about that maybe in executive session or one-on-one.
Thank you.
May I weigh in just a little bit on this?
Yes, Mr. Ray.
Recently, my family was involved in a payments of proceeds issue that became a class action. And what was presented to the fairness hearing and throughout a long procedure, which went on for months with many, many days, long days of presentation of exhibits and testimony, I provided 54,000 documents that had to be reviewed. And I can't imagine the commission having the time to look at that contract issue that we had. And that's pretty much true every time one of these things comes up. If it's just simply whether measurement and price, sale price was disclosed properly, that's easy to look at. But when it becomes a contract issue, it has to do with transportation and I mean many, many very complex concepts that might be contained in every contract in a drilling and spacing unit with all of the different tract owners. So I just wanted to give an idea of the scope and magnitude of what these things are when they are a contract issue. And that's all I wanted to say.
Thank you, Mr. Ray. Do we have further questions for this panel? All right, seeing none, thank you very much for bringing your perspective, your unique perspective to our proceeding. It's an important perspective and we appreciate your testimony. We will Zoom you away and bring on our next panel. Ms. Larson, is it Colorado Rising? Are they the next panel?
Yes, they are. So we will locate Mr. Salazar and have him join as a panelist.
Good morning, commissioners.
Good morning, Mr. Salazar.
Shall I proceed?
You can proceed. Thank you very much. We look forward to hearing from you.
Thank you very much. Good morning, commissioners. Again, the Rule 500 series is a bit of a sore spot for protestants and other parties who oppose oil and gas permits. It is not an unfair statement to say that in the past, hearing officers and commissioners did their level best to make the playing field about as tilted as possible toward the oil and gas industry. As I said in my testimony in the 300 series, for a decade, there wasn't an application permit the COGCC didn't like. After my term was over and I started representing communities and people in this process, I witnessed unrepresented working people given arbitrary deadlines by hearing officers to reply to pleadings, or hearing officers would schedule hearings with very little notice and order mineral owners to either physically attend the hearing or suffer the consequence of having their protest dismissed. Imagine the horrible choice people faced between having to be at their job and wanting to protect their property rights. Up until last year, mineral owners were not even allowed to conduct discovery. That all changed when my organization challenged this practice in federal district court, and Judge Jackson ordered the COGCC to allow us to conduct discovery. So it's no wonder that the legislature created a better balance through Senate Bill 19-181. Series 500 is supposed to create the due process to which mineral owners are entitled. With the August 17, 2020 redraft 500 series rules, we want to touch upon a few things. And first, I want to thank you for the rules. First, we remain in steadfast disagreement with the commission that it has the power to force pull mineral owners who are opposed to entering into relationships with oil and gas operators. We believe that force pulling violates the Colorado Constitution's prohibition to take people's private property for the benefit of private companies. It's actually a constitutional provision that prohibits what you're doing. Second, the commission is not empowered to grant variances, no matter the legal gymnastics found in Rule 502. The Colorado Court of Appeals in a 2006 case entitled North Avenue Central versus City of Grand Junction stated that request for variances is basically a request to deviate from the act. I mean, look at your variance language. Essentially, an oil and gas operator can seek a variance when, quote, it has made a good faith effort to comply or is unable to comply with the commission's rules or orders. Oddly, why is the word statute missing from that sentence? I ask because the more important and prominent legal authority is state statute. Nonetheless, if an oil and gas operator is unable to comply with state statute, commission rules, or orders, and those rules and orders are premised on first protecting public health, safety, welfare, environment, and wildlife resources, then their permits should not be granted or they should not be allowed to continue their projects. The language of Part C2 then makes things even more confusing. The proposed rule states that the requested variance will not violate the basic intent of the act. So let's game this out a little bit. The oil and gas operator is requesting a variance because it cannot comply with the act or commission rules or orders. Thus, by definition, a variance would be a request to deviate from the basic intent of the act. Trying to square the language in the redraft rule, the commission takes the unusual step to create a right not afforded to operators in the statute. Rule 502c3 states, the requested variance contains, quote, reasonable conditions of approval or other mitigation measures to avoid, minimize, or mitigate adverse impacts. What does reasonable conditions mean? Where is that found in statute? Frankly, the operator should not have been granted a permit in the first place if their initial application for permit did not already demonstrate avoiding, minimizing, or mitigating adverse impacts. Also, while the commission and operator are part of this variance process, where are the mineral owners and others who may be affected by the granting of such a variance? Do they not have rights in this process? I'm sorry to say that if variance language remains in the rules, we'll have to take this matter to the district court. The commission cannot add to or delete from its organic statute. You can only operate within the statutory authority granted to you by the legislature. Next, under Rule 505, evidence in support of an application, why is cumulative impacts not a part of the application? How about financial assurances? Financial assurances go directly toward the welfare part of public health, safety, and welfare. Finally, and going full circle, let's discuss discovery again. The United States Supreme Court and Colorado Supreme Court have thoroughly addressed a person's right to discovery in an administrative process, just like a judicial process. These rules give hearing officers way too much latitude to deny discovery without affording a person rights to appeal these discovery orders before a hearing. We would recommend that language be included allowing party to file an interlocutory appeal to the commission on a discovery dispute. This is not an unusual request. Even in litigation within the courts, a person has a right to file an interlocutory appeal on discovery issues to a higher judicial body. And just as a note, under 515, Why is the commission requiring attorneys be a resident of Colorado and maintain a law office in Colorado? Under Colorado Supreme Court rules, if you're licensed in Colorado, there is absolutely no requirement to be a resident or maintain an office in order to represent a client in Colorado. This rule is just arbitrary and capricious. I'm happy to answer any questions.
Thank you, Mr. Salazar. Do we have questions for Mr. Salazar? Seeing none, thank you for your testimony and your filings. We will now move to Gunnison County, who I believe is next. I see we have Mr. Baumgarten with us. If you want to unmute yourself. Mr. Baumgarten.
Yes, sir, I'm here.
Oh, great.
I'm sorry that I made you wait. I apologize.
No problem. We look forward to hearing from you. Did you have anything to share with your screen, or is it just oral testimony?
Oral testimony, please.
Very good.
Ready to go?
Ready to go.
Good morning. I am David Baumgarten, County Attorney for the Board of County Commissioners of Gunnison County, Colorado. I will today address only the variance process identified in the Draft 500 series, and in particular, the authority granted to the Director by the Draft Rule 502A. It is important for me to preface my comments that they are no reflection on any director. I've worked well with and greatly respected each director with whom I've worked for the past 30 years. Draft Rule 502A reads in full, variances to any of the commissioner's rules or orders may be granted in writing by the director if the request does not implicate public health, safety, welfare, the environment, or wildlife resources without a hearing upon written request by an operator to the director. One must begin then with a definition or notion of what a variance is. A variance is a deviation from a set of rules in a duly adopted code. A variance can act as an essential safety valve, and the issuance of a variance may be nearly unheard of for a particular regulatory entity, or it may be common. So a first issue for this commission is to decide whether a variance from a commission rule or order ought to be extraordinary or common. You have not done so explicitly. The second issue for the commission to decide is where the authority to grant a variance should be vested. Gunnison County suggests that the draft Rule 502A inappropriately makes the grant of a variance a common, easily obtainable change to any commission rule or order. Draft Rule 502A also makes the director's grant of a variance virtually unchangeable by the commission. The only constraint 502A places on the director is that the variance does not implicate public health, safety, welfare, the environment, or wildlife resources. But the word implicate in Rule 502A is neither defined nor is it meaning certain. Rule 502A does not provide for the following fundamental administrative law processes. Rule 502A does not require pre-decision notice to anyone, not to the landowner, not to the local government, not to any person or entity, and not to any other agency, except in the case of a variance to rules applicable to the underground injection control program. Indeed, the first time anyone other than the requester or director will hear of a variance request and decision by the director is when, pursuant to Rule 502F, the approval is posted on the Commission's website. The rule does not require an articulated or proved rationale or burden of proof, other than that the operator has made a good faith effort to comply or is unable to comply. And certainly without a requirement of notice, Rule 502A provides no opportunity for a response or objection. There also is no call-up or authority for the commission to overturn a director decision granted by the director. The commission will only receive a report that the variance has been granted. Perhaps Rule 503 could be strained to grant the commission authority to overturn a director grant of a variance, but that's not explicit. And again, without belaboring it, there's no definition of the word implicate. Is it the same as the language in draft 502C2, quote, will not violate the basic intent of the act? We lawyers are taught to caution against an exception swallowing a rule. Draft 502A provides an opportunity for just that to happen. There is now a full-time accessible professional commission which can entertain requests for variances. Rule 502A ought to be explicitly limited to a truly ministerial and non-substantive procedural variance. Thank you.
Thank you, Mr. Baumgarten. At this time, the commission has the opportunity to ask questions, and I would like to start by following up on the line of testimony that you just presented. And I know that you have been a longtime local government attorney. I was one as well for most of my career. And in local government land use codes, we're familiar with the concept of variance. And we're going to hear later from County Attorney Sheryl Rogers from Plata County, who speaks to this in her testimony as well. And I wanted to give you a chance to sort of amplify, but from a local government perspective on land use and variances, it was generally seen as somewhat of a high bar for a variance to be granted. And it was also something that was done, generally at the Board of County Commissioners as opposed to an administrative process. We've heard previously from some other stakeholders that they would like this to go to commissioners, that they would like the bar sort of elevated, and that the director ought not be, maybe 502 should just change and just have it go to commissioners. Can you amplify on your testimony, given your historic work as a county attorney and otherwise?
When I was writing these comments, I wanted to say that a variance must be an extraordinary remedy sought from the highest authority. But I don't know that I would have been honest had I said that. And so I went and checked many other jurisdictions and found that there are some in which a variance is common and is allowed at a staff level. But I think the better practice is to make it be extraordinary so that the rule doesn't, the exception doesn't swallow the rule. And in your circumstance, because you've got a full-time professional board, ought to be made at the highest authority. With that one carve out being that there may be a procedural, non-substantive variation. I couldn't file it today by 5 o'clock because I had to go to the hospital. Can I file it on Tuesday morning? Something of that nature, so that there really is a safety valve, but that safety valve is a limited one.
Thank you for that, and you can certainly make additional filings if you like. Could there also be, and you mentioned this in your testimony, I'm going to get to you, Ms. McGowan, in just a sec, the concept of, can you explain to commissioners the concept of a call-up?
A call-up being the opportunity for, in my case, my Board of County Commissioners to hear either as an appeal or de novo, as if it was for the first time, a request. I'm not seeing that opportunity for your commission to either hear as a review or de novo a director's decision. All that happens is it is reported to you with no opportunity for you to review, modify, or overturn it.
Thank you very much. Commissioner McGowan.
Thank you, Mr. Chair, and thank you for your testimony today. And this probably just is going to piggyback onto maybe this conversation that we just started. Would you be supportive then of variance requests going onto a consent agenda that would allow for folks to, and the commission to question or ask whether or not a variance was appropriate?
Please, I don't know how your consent agenda works and if there is the opportunity for there to be public comment on something on your consent agenda. What I'm driving at is a request for a variance ought to be subject to a process where folks can know that it is occurring beforehand and have the opportunity to comment upon it. And if you can do that on your consent agenda, I think that might be the place for it to go.
Commissioner McGowan, follow up? Okay.
Nope.
Commissioner Messner.
Thank you, Mr. Chair, and thank you, Mr. Baumgarten. I appreciate your perspective on this. Let me ask you this question, just to make sure I think I understand your perspective here, is that you would find it appropriate to have a variance sought from a director with a very narrow set of sidebars, which would be ministerial and non-procedural, but you would still request that the final decision lie with the commission, and in that being that even in an instance where it is ministerial or non-procedural, it would still go to the commission for a final determination. I think, as I understand it, that at that stage it would go to a consent agenda on the commission schedule. My understanding is there would not be public comment on that unless a commissioner pulled it from the consent agenda for additional discussion. However, basing this on the fact that I think your suggestion is to put the sidebars so narrow on this potential director variance that there may not be a lot of instances that would indicate public comment. However, should there be public comment provided prior to hearing this on the consent agenda, I think that creates the opportunity perhaps for a commissioner to pull it from the consent agenda for additional discussion. Am I catching what you're saying there?
Two things, please. The first is I said ministerial and procedural, not ministerial and non-procedural. So I really wanted to constrain it to something that is not substantive. The second, regarding the question of a consent agenda, I just don't know how the commission's consent agenda operates and whether the public really gets the opportunity to be informed that in your case, the director's decision has been made. If that is not so, I would say it ought not go on the consent agenda, but be a regular agenda item.
Thank you.
And I think there may have been a third question that you're asking me that I'm neglecting to answer. I'm sorry.
Commissioner Messer.
Thank you, Mr. Chair. No, I mean, I think I understand. I mean, you hit the two questions I asked, but now I'm going to ask you another question.
Okay.
You're also suggesting that generally speaking, there should be language in the variances section, which is 502, that would indicate that variances should be extraordinary circumstances. Just a general statement. Is that what I'm understanding?
I think that's a decision for you to make, whether it is common or extraordinary. I view them to be extraordinary.
Okay, thank you.
Other commissioners with questions for this witness? Okay, seeing none, thank you very much for your testimony. It is very helpful to us as we think through the issues relative to variances in particular. Appreciate your historic perspective on that.
And again, I apologize for making you wait.
No problem.
Thank you.
Commissioners, with that, our agenda had us at 10:40 and taking a break. We are at 10:34, so we're ahead of agenda, which is always a good thing. So why don't we take a break and reconvene at 10:45, 10 minutes? Does that work? Okay, hello, folks. It is 10:46. We'll get started again. Ms. Larson, I have the Western Rural Local Government Coalition, City of Greeley and Los Animas County next. Is that right?
That is correct. And give us a moment and we will have those panelists in the meeting in just a second.
Good morning, Mr. Jacobs. Do you have others presenting with you?
Yes, Mr. Nguyen, Mr. Vaughn, Mr. Lapore, and my associate Hayden Weaver will be performing the share screen duties for our testimony.
Excellent.
Thank you. Are we ready?
Yeah, I think we've got everybody at this point. If Mr. Weaver wants to share his screen, whenever you're ready for him to do that.
Yes, thank you. Good morning, Chairman Robbins, Commissioners, Director Murphy. I'm John Jacobs, Counsel for the Western and Rural Local Government Coalition. With me today to provide testimony on the 500 series rules for WRLGR, Matt Lapore, President of Insight Energy Law, Kirby Nguyen, Oil and Gas Liaison for Garfield County, and Phil Vaughn, President of Phil Vaughn Construction Management. We have some concerns about and some specific requests regarding aspects of proposed rules 502, 511A, and 507A, B, and C. We'll begin with Matt Lapore regarding variances under Rule 502. Matt? You're muted.
All right, let's try that again. Good morning, everybody, commissioners, Director Murphy. With respect to Rule 502 variances, you've heard quite a bit about that this morning and yes, on Friday. Western Rural Local Governments supports the continued ability of the director and or the commission to grant variances from specific rules subject to the important conditions articulated in Rule 502C. That rule requires that before a variance is granted, the director or commission must ensure that the variance will not violate the basic intent of the act and that granting the variance will still allow for the protection of public health, safety, welfare, and the environment. It is impossible for rules of general applicability to anticipate every real-world situation that might arise. In my tenure as director, my experience was that operators sought variances only in highly unusual circumstances where complying with the details, the black letter of a specific rule was impossible due to those circumstances. It is also true in my experience that the director and staff granted variances under only those extraordinary circumstances and only when we were assured that the elements of 502C could be met. As you heard Friday, surface owner requests for variances sort of are the biggest slice of that pie. And those surface owners have a private property right to use their land as they wish, including in some cases leaving behind elements of the infrastructure of oil and gas, like a flattened area on otherwise slanted or sloped topography that they can use for their ongoing use of that land or an access road. In those circumstances, staff has a very detailed guidance document for Rule 1001C, Surface Owner Waiver for Final Reclamation. All of the elements of that guidance document must be complied with for that variance to be granted. We would submit to you that the need for a commission to hear those surface owner requested variances is unclear, and we would urge you to certainly maintain the right of the director or the commission to grant a variance under appropriate circumstances.
Thanks, Matt. We would now like to address proposed Rule 511A, which allows any person to request the commission hold a local public hearing to gather feedback on a proposed oil and gas development plan or comprehensive area plan. Turning back to you, Matt.
Thanks, John. As John mentioned, and as you all are well aware, 511A does allow any person to request a local public hearing. This is obviously a very broad standard, which does give us a little bit of pause. We do acknowledge that the commission has reserved the discretion to deny those requests or to limit the request or the hearing to one that a single commissioner or an ALJ or a hearing officer conducts. Our ask here is that where the relevant local government regulates oil and gas through its land use process, first, we hope that you all are going to be very engaged in that, as we've talked about during the 300 series. You as staff hopefully will follow that local government process and know to what extent the public has been allowed to participate. And we hope that you would give a very hard look to granting a local public hearing where the relevant local government had that good public engagement. Secondly, we would hope that you would be disinclined to grant local public hearings if the requester is someone who has no nexus to the proposed development. So someone from a different county, or for that matter, from out of state, we would hope that those would be things that you would look disfavorably upon. At the end of the day, this is the language that we proposed in our pre-hearing statement and our filings. We think still that limiting local public hearings to those requested by a relevant local government that does not regulate the siting of oil and gas locations would be the better standard. But we understand, we hear what we've heard, and we'll just ask that you consider the things that we've just said. And I'll give it over to Phil Vaughn.
Thank you, Matt, and good morning, everyone. Having served on a county planning commission for over 21 years and serving as a land planning consultant for over 31 years, I have extensive experience in local government hearing processes. Local government feedback includes notice public hearings before local appointed and elected officials and verbal and written public comments. Referral agencies then consisting of local, state, and federal governments are also included in this feedback process. These hearings and referrals to agencies for comment are typical of all proposed land use applications, and frankly, these are well rooted in local land use regulations and in state law. Public hearings and input are frankly a cornerstone of local government. This draft rule appears to provide opportunity for abuse and delays in the permitting process for no apparent positive outcome. I'll turn this over to John Jacobs.
Thanks, Phil. Next, we'd like to discuss Rule 507, contested hearing applications before the Commission. We will discuss why we think proximate local governments should not be granted automatic affected person status. Kirby Wynn will address this.
Thank you, John. We at the WRLG propose that Rule 507A sub 1 be changed to specify only relevant local governments and those public agencies with legal authority over the issues at hand be provided automatic affected person status. We believe proximate local governments really belong in the same catch-all category as all other persons as noted in 507A sub 2 and A sub 3, and need to make a showing in its request for hearing regarding its interests, the magnitude of impacts to its interests inside its own jurisdiction as well. This is not a great burden for proximate local governments to make a simple showing of their interests, and will ensure that proximate governments do become involved, as they should, as a result of substantive concerns and not automatically and without regard to reasonably anticipated impacts, nor the relevant local government's completed process. We have concern that granting such legal standing to a proximate government that otherwise has no jurisdiction in the issues at hand seems to relegate the Commission to mediating between two local governments who are already required to communicate and coordinate cross-border land use issues of all types. Further, proximate governments who may have an issue have a responsibility to actually participate in the relevant local government process and should not be highly encouraged to skip that step to raise issues only with the Commission. It's worth considering also that in a sequential permitting process, the relevant local government has already made a deciding decision, perhaps in collaboration with the Commission, if our 300 series proposal for Commission participation in local permitting is adopted as we propose. Lastly, if the rule is to be adopted without change, we again ask and urge the Commission to consider a far smaller appropriate triggering buffer than the current 2,000 feet that affords proximate local governments such overreaching power to negate and impair the deciding authority of relevant local governments. And with that, I'll pass it to Phil Vaughn for additional comment.
Thank you, Kirby. My personal experience includes coordination between counties and municipalities in Colorado to detail how these entities cooperate and communicate with one another during the course of land use application reviews. Local governments across Colorado enter into intergovernmental agreements, or IGAs, and other informal engagements on a regular basis to encourage and guide local government relationships. The COGCC should not interfere with or regulate this IGA and engagement process. Additionally, the COGCC should not serve as a referee for local governments. I'll turn this over to Matt Lapore.
Thanks, Phil. Commissioners, finally, we want to flag 507C for you. And the reason is we don't understand what it adds to what is already given to proximate local governments in 507A1 and 507B. So under A1 and B, it appears that a proximate local government can participate in a hearing on any application, and then specifically on a drilling and spacing unit application. So the question is, what is given to them by C that they don't already have? And our concern would be that this in some way allows a proximate local government to participate in absolutely any hearing, including one in which they were not within that 2,000 foot buffer, or maybe said better, the oil and gas activity at issue was not within that 2,000 foot buffer. So just a question, if you're curious about that, we are, and maybe the Assistant Attorney Generals can help us out there. Thank you. John.
Thanks, Matt. That concludes our testimony on the 500 series rules. We'd like to reserve our remaining time for closing, and we welcome your questions.
Thank you, panel, for your presentation. At this point, if we could have the screen share turned off, that would help in the question and answer part of this protocol. Do we have questions from the commissioners to this panel? Commissioner Messner.
Thank you, Mr. Chair, and thank you for the testimony. I do think that's a legitimate question. The difference between 507A1 and 507C. So I wonder if AAG Minor could talk us through that one a little bit.
Thank you. If I may, Mr. Chair, and Ms. Larson may also have substance to add here. The difference between those two provisions is that 507A1 essentially automatically defines certain governmental agencies as being affected persons when there is a hearing application that would affect them. I do think the wording of this provision has gotten some attention from various stakeholders, including the Western and Rural Local Government Coalition that just presented. So I do want to clarify a couple things. One is that it uses the defined term governmental agency. That is a term that is defined at the beginning of the 500 series to include federal agencies, state agencies, and local governments, as well as tribal governments. I believe a party on Friday may have indicated that it did not include tribal governments, but it does. The reason that there is another clause there that spells out including relevant and proximate local governments is that there are local governments, namely special districts, that would meet the Commission's definition of a local government, but wouldn't automatically have affected person status in every case. So there is a constraint there to not include those special districts who could still become affected persons by filing an application and seeking that status. In terms of, and then I believe it's also worth pointing out that a local government would need to meet the definition of an approximate local government, so be located within 2,000 feet of a proposed working pad surface. So that would not mean that any adjoining local government automatically has standing in an application that is filed involving any oil and gas operations in a neighboring county. It would only be in the situation in which there is something that would allow that government to meet the definition of approximate local government, which I believe, again, is 2,000 feet of the proposed working pad surface. Turning then to the interplay between 507A1 and 507C, A1 is essentially defining those governmental agencies that have affected person status, whereas 507C is explaining that sort of the mechanics of the Commission's hearing process. So if any of those entities that are listed in 507A1 wishes to participate in a hearing, they would still need to file an application so that the Commission's hearing staff know that that entity wants to participate. However, that petition would automatically be granted, and when it go through the process in 507A2 and 3 for sort of identifying whether the person meets the definition, because they automatically do meet the definition. So Ms. Larson, do you have anything to add to that, particularly with regards to the process, if I may have stated anything correct there?
No, thank you, Mr. Minor. I do not. I think you covered all the points I would have made. Thank you.
Thank you,
Excuse
Mr. Minor.
me.
That is helpful.
Chairman Robbins, just a quick clarifying question for AAG Minor. That application for approximate local government, should it not require that proximate local government to identify in the application that will be automatically granted under proposed 507C that the location at issue is within the distance that causes it to be approximate local government? The proposed 2,000 feet, we've suggested a shorter distance in prior testimony, but whatever that distance is, don't they need to say that in the application, or will you get errors basically of automatic grants of party status to proximate local governments that aren't certain or don't point that out in their application?
Attorney General Minor.
Thank you, Chair Robbins. I might in some ways think that this is a good question for Ms. Larson to address so that she can sort of clarify what hearing staff are looking at when they receive this type of application. I believe that, that sort of the purpose of using the working pad surface definition is to provide a great deal more clarity for purposes of measurement. I don't think that the commission's hearing staff routinely go out to sites with a measuring tape to make sure that something is exactly 2,000 feet away. But I think if there is a dispute over that measurement, which I would anticipate that staff's proposed changes in using the term working pad surface will really help clarify a lot of those measurements in just about every instance, that dispute about the measurement could be resolved through the ordinary hearing process. But perhaps Ms. Larson, if you have anything to add about what you and your team actually look at when you receive this application, that would be great.
Yes, thank you, Mr. Minor. So Rule 507F sets forth the elements that all petitions must include. So that would need a petition from approximate local government would need to include a statement about the factual legal basis for that petition. And at that point, we would expect approximate local government to attest to the fact that they in fact are within 2,000 feet of that working pad surface and have land use authority as it relates to potential impacts that they may be seeing from a proposed OGDP. So I would direct the commissioners and stakeholders' attention to 507F to look at the elements that must be included in the petition. And if we were to receive a petition from approximate local government that failed to meet the elements of 507F, we would certainly request that that petition be amended to reflect that information before we could have it granted.
Thank you, Ms. Larson. Are there additional questions for the panelists, or uniquely, do the panelists have additional questions for my staff?
Thank you.
All right, I'm not seeing any additional questions. I'm just looking at my notes real quick here. Okay, I don't think I've got any questions as well. So thank you to this panel for your presentation, and we appreciate your involvement. We will now Zoom you away and bring in the next panel, which I believe is a similar panel of Western counties, Plata County, San Miguel County, and Pitkin County.
Thank you all.
Thank you, Mr. Lapore, Mr. Jacobs, Mr. Vaughn, Mr. Nguyen.
Thank you.
Good morning.
Good morning.
Thank you, Mr. Chair. Maki Iatrides for La Plata County and San Miguel County. There will be 3 witnesses for us. There will be Commissioner Westendorf, La Plata County Attorney Sheryl Rogers, and Lynn Paget from San Miguel County. And the order will be, Mr. Chair, the Commissioner, Ms. Paget, and Ms. Rogers. And you can just go from one witness to the next without returning to me. Thank you.
Great. Commissioner Westendorf.
Thank you, Mr. Robbins, and thank you, commissioners. I appreciate the opportunity to address you again regarding this time the 500 series of the rulemaking. I'm Julie Westendorf. I'm a La Plata County Commissioner. That's the southwest part of Colorado, the Durango area. And as I mentioned last week when I spoke, that area is we have a mature field and have been in this oil and gas regulation business for a long time. Today, my comments will focus specifically on Rule 511A and B. And this is the provision as it relates to local public hearings. Our request today is specifically that rather than 511A making the assumption that a hearing would not occur if requested by a local government, that language be changed to create an assumption that a local hearing will be held if a local government requests that. We ask you to hold these local or basin-specific public hearings when requested by a local government. From Southwest Colorado, it takes a long time to get to Denver It's many miles and many hours, and it's I believe that in order for the commission to exercise its duties and responsibilities effectively, it is critical that the community members most affected by a project have a substantive and consequential opportunity to address the commission. Local public hearings are the best way for the commissioners to hear full and balanced testimony upon which to make your decisions. The commission has come to Durango for hearings in the past, and it has proved valuable to the commission as well as enlightening Southwest Colorado residents to the commissioner's work. Just this year, prior to the COVID-19 restrictions, the commission conducted a local hearing on mission change. And I think it was really helpful to those in attendance remotely or in person to hear the real stories of the people on the ground. And also, it's not just a voice of opposition or I don't want it to be viewed as an opposition viewpoint, but it also allows people who support projects or give an industry perspective in their local environment, their near home, that they wouldn't be able to do if meetings were only held in Denver. The proposed rules in 511B do not set up any standards for when a hearing should be held. Our request is that it be done purely at the request of a local government, but the standards could be applied for local public hearings that match or guided by the same kind of standards that exist for comprehensive area plans and oil and gas development plans. Those rules allow that a hearing would occur, but those rules provide that a hearing will occur unless there were specific findings by the COGCC as to why one was not necessary. That type of provision allows for or a type of provision that allows for a COGCC member to be physically present to conduct the hearing while others participate remotely could be an alternative to all commissioners attending. However, given that COGCC now consists of full-time members, there should be a strong preference for the physical presence of the commissioners. Just to respond real quickly to what a prior witness said, where they did not think counties outside of the jurisdiction where a project were to occur should have standing. I think basins don't follow municipal lines or county lines, and so having basin-specific hearings is appropriate. I'll pass it on to Lynn Padgett at this time.
Thank you, Julie. Good morning, Chair Robbins, Commissioners, Director Murphy, and Commission staff, and thank you again for this opportunity. I welcome questions from the Commission afterwards. I provided testimony during the 300 series portion of the hearing on several themes that are important to our local governments. These themes really must be holistically addressed across several role series to successfully provide better outcomes that protect public health, safety, welfare, the environment, and wildlife resources for all Coloradans, and also to practically implement the dual authority between the Commission and local governments. The Commission's attention to these themes is needed. First, local governments also have a mission to provide public health, safety, and welfare, and we also protect the environment, wildlife, and biological resources, which are essential to our quality of life and economies. Increased coordination and timely communication with local governments provides efficiencies and benefits to our agencies and operators. Local governments are emergency first responders, which requires coordination and communication from the Commission. Second, the Commission should communicate directly with local governments and should provide concurrent notices of all forms filed with the Commission, including activities and applications. Notices should be shared with us in real time and not just posted on the Commission website. Third, alternative location and cumulative impact analyses are the most effective tools for identifying potential direct and cumulative impacts to truly protect public health, safety, welfare, the environment, and wildlife. These must involve consultation between the Commission, local governments, CDPHE, and CPW. They should also be standard procedure. Consultations with Colorado Natural Heritage Program, CNHP, and Colorado Geological Survey, CGS, should be incorporated into the various rule series. Variances should not be allowed to degrade or skirt this planning. Fourth, the Commission regulates the operators. Operators should be required to be in good standing with all Commission requirements such as updated information, financial guarantees, conservation levies, and first purchaser information, as well as local requirements. For the 500 series rules, Rule 503G4, 529D2 and 3 should be amended to say the Commission will consult with CDPHE, CPW, CNHP, and CGS. In Rule 503G4, local governments should also be allowed to be the applicant for an order finding violation, OFV, application. Rule 525D3 should allow consideration of confirmed violations in other jurisdictions to determine patterns of abuse, gross negligence, or knowing and willful misconduct. The rule should also address potential loopholes. Thank you. Our next witness is La Plata County Attorney Sheryl Rogers.
Commissioners. I too want to address 502 relating to variances. Preliminarily, we appreciate the transparency that has been created in Rule 502E and 502F where variances are publicized. However, we have three concerns with Rule 502. First, as drafted, every rule is subject to variance. We assert that variances should not be used to avoid those rules that create certain processes and the attendant notice and public hearing requirements. Variances might be appropriate for ministerial decisions and even decisions about compliance with substantive standards, provided the alternative is equally or more protective. But there's no substitute for local government consultation, notice, and public process. If changes are not made, local governments and others will fairly expect an opportunity for consultation or prior notice of certain actions, only to find after the fact that a variance was granted and they no longer have a role in the process. And as previously noted by San Miguel County, we would learn this only after mining the website. Second, we urge you to require consultation with local governments when a variance is requested because it is inefficient for COGCC to entertain a variance that might not be permissible under local regulations. Given the level of importance this commission seems to place on collaboration with local governments and community engagement, variances from rules requiring consultation and public notices and hearings should not be allowed, and consultation with local government should be required when a variance request is first submitted. Our final concern with Rule 502 is that an operator may gain a variance if it is shown it has made a good faith effort to comply with the requirement contained in the rules. We would like to see this criterion eliminated for several reasons. First, proof of the existence of good faith is notoriously subjective and difficult. This criterion invites proof of bad faith, which makes the process more contentious and confrontational than necessary. Second, a good faith effort to comply essentially turns every standard or rule into a guideline rather than a rule, because an operator need only make a well-intended effort at compliance. If there are continuous requests for variances related to reclamation, perhaps that is an indication that the rule needs to be revised to include limited exceptions as requested by a property owner. The COGC should follow other areas of Colorado law that meet the process for variances, that limit the process for variances to those situations where the hardship complained of is due to circumstances or conditions beyond the applicant's control, or due to conditions uniquely affecting the property or the resource. Finally, I want to address Rule 525 that stops penalties from accruing each day a violation continues if the operator is engaged in good faith negotiations with the commission. We think it should go without saying that an operator has a responsibility to negotiate in good faith, and are concerned that this provision acts as a disincentive to resolve violations and negotiations quickly. If it is necessary to recognize the operator's good faith efforts, they should be taken into consideration to offset the amount of the penalty at a later stage in the process. That concludes our testimony.
Thank you, County Attorney Rogers. I'll start with this panel. I guess my first question is an ask. You had several pointed rule edits, and Ms. Paget had them as well. And Ms. Paget went through them so quickly, I didn't type them all up. Do you guys have this in a document, or could you put it into a document and email it to Ms. Larson so that we see specifically? And I know that some of this is within your testimony that I read, but if there's a way to sort of summarize it into a short document, that would be helpful to commission so that we've got all of the proposed edits. So that's my ask. Then my question for Ms. Rogers, I don't know if you were in the House when I spoke with Gunnison County Attorney about variances, but I wanted to give you an ability to sort of supplement your answer, I'm interested in the issue that you raise of removing the standard of good faith and elevating the variance criteria so that it's more of a hardship. I come at this again from the perspective of a county attorney, and variances were often difficult to obtain. I understand, and I'm trying to balance the concept that there are times when variances are important, and it has been, as I see it, sort of part and parcel of how things were done, but I don't know that it's necessarily how things need to be done as we implement 181. So I don't know, do you have anything further to add to, the sidebars, the standard, and also do you have anything to add with regard to director versus commission?
Thank you. I think a few things that we have learned is there does need to be a balance. If you try to draft a rule for everything, it becomes overly bureaucratic and you get stymied just by the process. But on the other hand, you want your rules and regulations to have integrity and to mean something. And so the way that state law and most counties function is a high standard is set in order to get a variance from a rule or a regulation. Those questions of variances normally go to a board of adjustments. And to receive that, you actually have to have an affirmative vote of a super majority, so 4 out of 5 of them. And there's some additional criteria that does not exist in your proposed rules. And typically that is a hardship on the part of the applicant, and it needs to be a non-monetary hardship. It's not enough to say that you just can't afford it, therefore you should receive a variance. And then normally there has to be some sort of special circumstances or conditions that are peculiar to the property, to the resource, that make it almost impossible for them to comply. And then no special privilege. You want to make sure that everyone is being treated similarly. And then the variance granted is the minimum that's necessary in order to accommodate or to compensate for whatever the problem that's being posed. And then it needs to not injure the public. So those are our criteria for variances. And then with exceptions, I've been listening to the conversation about reclamation, and I do think it sounds to me as if that's where the majority of your variances come from, and there's some repetitiveness in the nature of the requests that are being made. So your rules could set forth exceptions that could be made for reclamation and within the purview of the director, so that the director would have the flexibility necessary to make those with respect to driveways or pads to be maintained in place, and give the director some sidebars in which to operate with that discretion. And I think by articulating those exceptions, you also benefit the public and operators. Sometimes you don't want to have like a second set of books with alternative rules and regulations and exceptions that one does not know about unless they hire the right consultants or are particularly savvy. It should be obvious and transparent what those exceptions are and that they're available to everybody.
Thank you very much for those thoughts and that testimony.
I'm sorry,
go ahead,
Mr. Chair. One place where I think I would deviate from Mr. Baumgarten's testimony, as I indicated, I do not think that it is appropriate for variances to exist as to all processes. When you have said that consultation will take place, or that a certain decision is important enough, either from a due process or a transparency perspective, to require a notice and a hearing, there should not be variances to those processes.
Ms. Larson, can I call upon you to sort of speak to that? Because I don't think that we ever intended that the variance would vary the ability or the rulemaking requirement that in certain circumstances we will have consults. At least that's not my thought. what we're trying to do.
Certainly, and I apologize. If I understand correctly, Ms. Rogers, there's a concern that the variance process would allow for a consultation with another state agency to be relaxed or not implemented. Is that accurate?
The statement of basis of purpose and also the rule says that every rule is subject to a variance. So that's
Yes.
how we're getting there.
Thank you. So it's correct in our draft rules and in the SBP, we did not go through and identify which rules we would consider to implicate public health, safety, welfare, and the environment. Staff's approach at this point in the draft rules is to note that if a request is ministerial, procedural, and those are the terms that we use in the SBP, then that would be something staff would consider and would be allowed for the director to issue a variance on. But if it implicates public health, safety, welfare, and the environment, that would not be something staff would issue a variance on, and that would need to be referred to the commission. So to your point, Director Robbins, the consultations that we set forth with CDPHE, with CPW, those most certainly implicate public health, safety, welfare, and the environment, and therefore staff would not be in the position to entertain any variance request. If an operator, as part of its OGDP, sought to have those consultations waived, it would need to include that request in its application. That would then be considered by the commission. So,
yeah. Thank you, Ms. Larson. And I guess I just have kind of a statement for everyone at large. Is I think that we, at least I, look to adjust the variance language along with the thoughts that I've indicated. But I would point out that variances are it's received a lot of attention this morning, and it's not something that is largely used. So I think that the level of attention versus the amount of use is a little bit disproportional. At any rate, that's just my statement. Any other questions for this panel from commissioners? Okay, seeing none. Commissioner Westendorf, I did want to let you know that I agree with your thoughts. If the local government wants a local public hearing, I think that makes sense, and we ought to do it in the area of the local government once we're outside of pandemic Zoom calls. And while we're still in pandemic Zoom calls, then we should do it under Zoom. But anyway, thank you for your testimony. Thank you to the panel for your presentation and for your being with us this morning. We appreciate hearing from the southwest corner of the state and your distinct difference with regard to development in your neck of the woods. Okay, with that, this panel will Zoom away and we'll bring in Small Operator Society. Is that right?
Good morning, Chairman Robbins. This is Jason Moore. We also have Jessica Donahue, so I think we're ready to go whenever you are.
Okay, I think we are ready. Take it away, Mr. Moore.
Thank you, Chairman Robbins, Commissioners, and Director Murphy. I hate to belabor my name is Jason Moore. I'm counsel to the Small Operator Society. We also have Jessica Donahue, who's going to be speaking from a small operator perspective. Not to belabor the 502A variance point, but we do think it's an important point. We agree that the language as currently drafted is somewhat ambiguous and overly broad and could result in just about every variance request requiring a full commission hearing, and how in particular that's a problem specifically for requests for variances from reclamation requirements that are initiated by a surface owner request. So with that, I'm going to turn it over to Jessica Donahue to add a little bit more color about how our group of small operators approaches variances, their importance, and why in particular some of those variance requests relating to reclamation shouldn't require a full commission hearing, and that should be clarified in the rules. So with that, I will turn it over to Jessica.
Good morning, everyone. My name is Jessica Donahue. I am a Colorado resident for nearly 20 years now. I am a mother to a quirky teenager who just began his freshman year of high school. I am an environmentalist. I'm also a compliance specialist who's been in the oil and gas industry for over 15 years. Sorry, I'm trying to share my screen and read. I am here on behalf of the Small Operator Society to offer some perspective on the 502A variance process and concerns with how it is currently proposed. Variances are a critical tool on, for both the commission and operators, especially our group of small operators, which mostly operate in remote rural areas of the state. Variances give COGCC staff and operators flexibility to address issues most often requests from surface owners or local governments in a timely and efficient way. In my experience as one responsible for seeking variances, variances are not used often. We use them only when an extenuating circumstance absolutely necessitates it. Variances are also an integral part of the structure of COGCC's rules, as they are in all other agencies' rules. The revisions to the 200 to 600 series rules specifically contemplate the use of variances in several instances. In fact, the statement of basis refers to the term variance more than 40 times throughout the 200 and 600 rules. SOS agrees with the testimony you heard on Friday from the other industry group that variances are most often sought out at the surface owner's request during reclamation. In our experience, we most often need to seek a variance because, for example, a surface owner would like to leave part of their property level so they can stack hay or eventually build a barn, something the owner would be entitled to do anyway outside the context of the COGCC reclamation process. During some of the other testimony you have heard, you may have gotten the impression that operators seek a surface reclamation variance as an easy way to get out of doing reclamation. That couldn't be further from the truth. Honestly, doing the reclamation prescribed by commission rules is generally the easiest option for an operator. When a surface owner requests a variance from what COGCC rules require, the operator and COGCC technical staff must put in many hours of work into evaluating the specific variance request to ensure that it can both accommodate the surface owner's request, if possible, and still protect public health, safety, welfare, and the environment. After all, the COGCC's guidance document for doing a surface reclamation variance is 137 pages long. It is not an easy get out of reclamation card. There is a lot of thought and time put into the request, and even then, not all variances are approved. I would also like to clarify that if a variance is requested, it does not absolve an operator of all reclamation requirements. Variance requests are typically very targeted to address a specific surface owner concern. However, the location must still comply with all other requirements, including inspections, site stabilization, and erosion control best management practices before it can be fully relinquished to the landowner. While reclamation is not a swift process by any means, SOS believes that surface reclamation variances requested by the surface owner should be clearly designated as an administrative decision that can be made by the director with the support of COGCC technical staff, because they simply do not involve adverse impacts to public health or the environment that need a full commission hearing. While SOS appreciates that we now have a full-time commission that meets weekly, I would ask you to place yourself in the boots of a typical surface owner that SOS members deal with. They are often farmers or ranchers on the west slope or northeastern parts of the state. That rancher may now be required to hire a lawyer for the hearing. There is a formal 60-day notice process, an expanded universe of people who may be able to participate, and as Mr. Salazar has just pointed out, the need to attend the hearing in Denver can be daunting for people, which could require a rancher to drive 3 to 4 hours each way, missing a day of work or on their ranch. All for a request to leave a flat spot on their property, something they would be entitled to do anyway. SOS is not advocating that all variances should not have a hearing. The example given here, where a surface owner requesting a modification to reclamation should be a ministerial approval versus other unique situations that may arise that warrant a hearing before the commission. And while other operators currently use variances sparingly, that could change with the revised rules, which often apply statewide regardless of type or location of operations. That is a concern given that there are approximately 6,000 permit applications in the queue. Come December 1, when these new rules become effective, most, if not all of those permits will have to be modified to comply with the new rules and be reevaluated by COGCC staff and ultimately by the commission. And many of these permit applications may now involve variance requests. Requiring a hearing for routine variance requests could unnecessarily take up much of the commission's time and resources. On a last note, SOS does support the other industry group's position that the penalty reduction should be preserved. I'll now turn it back to Jason to discuss our specific requests. Thank you for your time today.
Thank you, Jessica. Now to our ask. We've heard a lot of comments about the confusion or ambiguity with current Rule 502A and relates to the, implicates public health, safety, welfare, and the environment, and how that interplays with the reference to ministerial or procedural in the statement of basis and purpose. I think we would suggest that you replace the implicates language in 502A with the actual language from the statement of basis and purpose, and refer to ministerial or procedural to clarify that. And then in the statement of basis and purpose, to clarify that these requests for variances to reclamation requirements at the request of surface owners count as a ministerial request and can be administratively approved by the director. And with that, that concludes our testimony, and we're happy to answer any questions.
Thank you, Mr. Moore. Thank you, Ms. Donahue. Appreciate your testimony. This time, we have commissioners with an ability to ask questions of either of you. Looking at fellow commissioners if we have any questions. Great. Oh, there we go. Commissioner Nanjapa.
Thank you, Mr. Chair. This is a bit of a general question, but we've heard a lot about how often the requests for variances revolve around reclamation and are often supported by or requested by the landowner directly or the surface owner. Can you give me some examples of other variances that are outside of reclamation that you've been involved in, or that some of the small operators have had to request?
Of course. A common one would also be for in 603, I think it was initially 603B and is currently 603F in the proposed rules. It states, COGCC rules state that you cannot have extra equipment on a location. They want locations kept very tidy, but sometimes there's occasionally situations where perhaps if you have, for example, say frac water supply tanks, and your next location is not ready to receive the tanks, you may request a variance to store those tanks on a location for a time period until the next location is ready to be moved to. That's also a very common variance that operators may request.
Thank you. Any further questions for this panel? All right. Thank you very much for your testimony. Thank you for being with us today. We will zoom you away, bring in TEP Rocky Mountain LLC. Is that right, Ms. Parson?
Yes, that is correct.
Thank you, commissioners.
Thank you.
Good morning, Mr. Jewell. Are you on your own today, or do you have others with you?
Yes, sir. Just me this morning.
Very good. Got you down for a 5-minute presentation. You may take it away at your leisure.
Thank you, sir. Good morning again, commissioners and staff. Again, Michael Jewell on behalf of Terra Energy Partners and its wholly owned subsidiary, TEP Rocky Mountain LLC. Thank you again for your continued attention, particularly given our myriad of positions and passions. I have only 2 quick earworms for you today. One of somewhat redundant support of several parties about the APA and the avoidance of standing litigation, and a new point about standing, epidemiology, and confounders. First, when analyzing a particular statute that confers standing on a particular plaintiff, there are 3 factors to be considered. 1, whether the statute specifically creates such a right, whether there is any indication of legislative intent, and whether it is consistent with the statutory scheme to imply such a right. As demonstrated earlier, failure to comply with this standard can lead to overly narrow or overly broad definitions of standing. Avoiding these extremes means the Commission's work does not get tied up in needless litigation over procedural matters. Let's work with industry, staff, and concerned stakeholders to ensure that the final definition of standing, particularly in 507A2, does not conflict with the APA. Secondly, when reviewing standing and the factual content of affected persons under Rule 507A3, the Commission must carefully take epidemiological confounding into account. As I train my medical and public health students at the University of Colorado School of Public Health, administrative law is in an oddly precarious position. Agencies must govern under its legislative mandate, as you are doing, but using science that is properly tailored and falsified accordingly. If an agency governs from imprecise scientific conclusions or no studies at all, then it risks having its position easily toppled in district court. Many, if not most, of the studies brought before you concerning the negative effects of oil and gas development are retrospective studies. This means on their faces, they do a great job of illuminating population health data, but without pointing to causation on the individual level. Deriving standing on this basis is called an ecological fallacy. Making decisions or definitions based on a fallacy as this leads your decisions to being overturned. Another issue of properly tailored science is the need to use studies that soundly account for confounders. Confounders are variables in the environment that can lead to biased results in a study. You've heard from several scientific experts, many who trained in epidemiology from the same text that I did, which concludes, quote, failure to take confounding into account in interpreting the results of a study is indeed an error in the conduct of the study and can bias the conclusions of the study. The studies out of the greater Wattenberg area contain one important confounder vis-a-vis my client, the types of drilling and development. Terrace drilling in the Piceance, as you know, is usually more traditional vertical or directional drilling, excuse me, without the so-called industrial presence that you come to contend with in these hearings. This means the environmental impacts are not only less, but also of a different nature than larger horizontal development projects. This must be taken into account. For these reasons, I urge you to consider facts of location and study type before affected persons can enjoy standing that would otherwise be beyond the scope of legislative intent. So to conclude, number one, please ensure your final definition of affected persons does not run awry of the APA. And number two, avoid the one-size-fits-all application of facts when it comes to the definition of affected persons, especially when assessing such statements under public health in order to avoid committing the ecological fallacy. Thank you for your time.
Thank you, Mr. Jewell, for your testimony this morning. Do commissioners have questions for Mr. Jewell? Commissioner McGowan.
Thank you, Mr. Chair. Thanks for your testimony today. I am not sure I'm understanding what you think is not aligned with the APA in the definition of standing in the proposed rules.
Yes, ma'am. Thank you. I will say the August 17th red lines addressed some of these better. But for instance, there's language such as the magnitude of impacts or a reasonable relationship between the interest claimed and the activity regulated. Perhaps some of that can be tweaked. And again, I'm borrowing from some other concerned stakeholders that are not with industry who have raised the same issue. But we just want to make sure by the time this rule is finalized, we're going to avoid both extremes. And some of this language can be overly inclusive, some of it can be a little too sharp, if you will.
I think that satisfied Commissioner McGowan. Thank you. Any other questions for this witness? Very good. Mr. Jewell, thank you for presenting to us this morning and for being a party to our meetings. We appreciate that. We will now Zoom you away. And Ms. Larson, I believe you mentioned that Weld, Air, and Water, who are on the agenda, are not planning on presenting. Is that right?
That is correct. So the next party to present would be Weld County.
Okay, and then we've got Wildlife and Biological Resource Coalition as the last party, but I believe they are only ready to present after a lunch break. Is that right?
That is correct.
Okay, so we'll take Weld County and then we'll take our 45-minute lunch break. So if we want to bring Mr. Barker into the room. Hello.
Good morning.
Good morning, Mr. Barker. I only have you down for 2 minutes. Is that accurate, or did you want more?
That's accurate.
Okay. Well, we look forward to hearing from you, and we're glad to see you this time.
Yeah, it's with the help of my IT director, so I'm good. Thank you, Mr. Chairman, Commissioners, and Director Murphy. Weld County supports the proposed 500 series rules with one exception. That is the grant of automatic standing to proximate local governments in contested hearings in Rules 507A1, 507B, and 507C. We have 3 reasons for our opposition. First, automatic standing allows proximate local governments to contest the siting of oil and gas locations within 2,000 feet of their borders strictly for political or philosophical reasons without having to prove up that they are affected persons through the criteria found in Rule 507A2 and 507A3. Second, automatic standing allows proximate local governments to bypass our county land use process and go directly to the commission with their concerns or objections. Finally, proximate local governments have no legal authority over oil and gas locations 2,000 feet into our jurisdiction. We note that other governmental entities such as fire, sanitation, and water districts who actually provide service in the 2,000 feet and therefore have some legal authority over the oil and gas locations do not get automatic standing. Why the difference? For these reasons, we respectfully request that you strike the words proximate local government from Rules 507A1, 507B, and 507C as suggested by the Western and rural local governments. Thank you.
Thank you, Mr. Barker. You accomplished quite a bit in 2 minutes. I appreciate that testimony. Do commissioners have questions for Mr. Barker? I'm not surprised. Your testimony was very straightforward. And so thank you very much for your testimony, Mr. Barker. We will allow you to be zoomed away, and we'll look forward to seeing you in other portions of the proceedings. At this point, I believe we are at lunch break, even though it's a little bit early. Is that, commissioners, okay with that? Thumbs up. So it is approximately 11:45. We had set aside 45 minutes. Does that still sound reasonable, folks? Okay, then let's return at 12:30. Thank you.